Hi, and welcome to Marriage and Family Therapy 8102 at North Central University, a brief overview of the divorce process and a marriage and family therapist's role in that process. According to LegalZoom.com, the divorce process begins when one of the partners filing a divorce petition, which is then served to the other partner. The petition is filed in the state court in the county in which the partners reside. The dissolution does not have to be filed in the same state in which the marriage occurred. After the petition is served, if both partners agree to the divorce, the acknowledgement of service is signed and the process moves on to the next stage. However, if either of the partners refuse to sign the acknowledgement, a professional process server may be hired to officially serve the divorce agreement. Once the acknowledgement of service has been officially signed, the state's waiting period for finalization begins. In Texas, there is a 30-day waiting period before a divorce can be finalized. If there's a disagreement or dispute on the separation of any personal belongings, property, or child custody issues, this period will typically extend much longer than the designated waiting period, as the case must be settled in court, with a judge overseeing the divorce proceedings. The respondent, the partner who is served, is given an opportunity to respond to the original petition and given the chance to state areas in which the original petition that they do not agree to. The partners then have to negotiate these differences through mediation or through the collaborative divorce process. In some cases, a judge may require the partners and any affected children to attend therapy and/or assessments to provide the judge with further information to make an informed decision regarding what's best for the welfare of the affected children. If an agreement still cannot be reached, they will have to go to trial and have the differences settled by a judge. The order of dissolution is then drafted and officially ends the marriage. The order or dissolution spells out how all the assets and debts of the marriage are divided and how child custody and support are to be managed. When dealing with child custody and co-parenting, it is noted that there may be high parental conflict initially, while most parents are increasingly able to work together for the betterment of their children as the anger and conflict diminish. However, between 8 and 15% of parents are unable to set aside their differences and continue to engage in high levels of conflict with their previous partner. This small group of parents are unable to settle their differences and continue with litigation in the years following the separation, creating an environment of hostility and tension. As a result of these continued conflicts, the American Psychological Association has presented a set of guidelines for the practice of parenting coordination. Parenting coordination is defined as the non-adversarial dispute resolution process that is a court-ordered or agreed upon by divorced or separated parents who have ongoing patterns of high conflict and/or litigation about their children. The idea is to focus on the best interest of the child by assisting parents with complying with established court orders, making timely decisions in a manner consistent with the children's developmental and psychological needs, to reduce the amount of time damaging conflictual contact between the parents in front of the children, and to minimize relitigation about child-related issues. Often, mental health professionals, including marriage and family therapists, are utilized in the role of the parenting coordinator. As they undertake the role of the parenting coordinator, there are several issues that need to be addressed and boundaries to be established. The first of which encompasses the therapist to try to understand the complexity of the parenting coordinator role and to distinguish it from other professional roles. This means that the therapist must work to maintain professional boundaries and to avoid incorporating clinical, forensic, or legal practices that are beyond the scope of the parenting coordinator role. The therapist's role as the parenting coordinator is to work to reduce conflict between the parents by providing education, guidance, and coaching while facilitating discussions about the children's needs and the parents' priorities. The therapist also works to gather information for assisting in the resolution of disputes as they arrive and negotiating decisions as needed. The therapist also encourages compliance with established court orders and works to improve communication between the parents. The therapist also works to gain and maintain specialized knowledge and training in psychological areas that are necessary to the parenting coordinator role. It is vital for the therapist to be up to date with current dispute resolution techniques and how to maintain a working alliance with parents involved in the parenting coordinator program. It is also important for parenting coordinators to understand the legal authorities, terminology, and administrative procedure changes that affect their role as a parenting coordinator. Therapists aspire to create a healthy environment for children and encourage appropriate parent child relationships while ensuring the safety of all family members in the process. They also strive to be aware and maintain ethical and multicultural boundaries while working as a parenting coordinator. It is the job of the parenting coordinator to maintain records that are admissible to court in the event of being subpoenaed. It is necessary for the therapist to maintain records that are free from bias and provide enough information to satisfy the legal process in regards to decisions made during the parenting coordination process. There are several considerations for evaluating child custody arrangements and or the mental health of a caregiver. There are some situations which require the parents to undergo a psychological evaluation to determine which parent having custody is in the best interest of the children. In cases of mutual domestic violence and or serious mental health issues, a judge may require that the parents and possibly the children undergo evaluation to determine the safest environment for the children. According to Ramage and Barnard, there are 5 critical areas of evaluation to be addressed during a custody evaluation. The first of these is the cognitive domain. This refers to individuals' ability to understand and apply concepts and the ability to self-reflect and apply insight. This also incorporates the family's values and the ability of the parents to agree upon intellectual endeavors, recreational activities, religious and moral pursuits, personal achievements, and independence. The second domain is the affective domain, or the ability of the individual to engage in cohesive commitment, expressiveness, satisfaction, and acceptance. This also applies to the elements of loyalty, trust, respect, and the general strength of affective bonds. The therapist also assesses the availability of emotional supports from the extended family and the level of effective attachment to activities outside of the home, such as community service or religious involvement. The third domain, communication and interpersonal reviews the parent's ability to relate warmly and cooperatively with others and their effectiveness at resolving conflict and engaging in goal-directed negotiations. The fourth domain looks at the structural and developmental components. Structural components such as the absence or presence of stress from areas such as education, work, and interpersonal, and whether the individual actions are consistent with said values, beliefs, or feelings. Finally, the fifth area of evaluation is the control, sanctions, and related behavior domain. It is possible for the individual to delay self-gratification for the sake of the others. This is an area that has to be evaluated. There are also several ethical considerations to look at when you're a therapist engaging in a child custody evaluation. As a therapist working with families in the divorce process or post-divorce adjustment period, there are several areas of ethical dilemma to consider. The first of these ethical issues is to determine who is the primary client. While the evaluators are advocates for the children and their recommendations should be made solely in the best interest of the children, there are times when they may be appointed or hired by a third party. It is imperative that the therapist explain their primary goal is determining the best interest of the children and that the children are the primary clients in this type of case. Dual relationships are another ethical consideration. The therapist must do their best to ensure that a dual relationship is not present and that they stay within their ethical boundaries as a therapist. Confidentiality is another ethical concern. It is imperative that the therapist notify all parties involved prior to evaluation that the evaluation process is not therapy and that any information shared during the evaluation process is not considered confidential and it may be shared with the court. Finally, it is important for the therapist to maintain an objective stance during the evaluation process to ensure that all information is presented in an unbiased manner. When you receive a subpoena, there are several things to take into consideration. According to the APA, when you receive a subpoena, you should first verify that the subpoena is a valid court order. In some states, the subpoena is not signed by a judge and therefore is not considered a valid court order as it is non-HIPAA compliant. If you find that it is a valid subpoena, Identify exactly what information it is requesting from you and whether you have the relevant information. If in doubt of the exact information being requested, contact the party requesting the information to clarify what is being requested. Efforts should be made to contact the client to obtain written permission to release the records if at all possible. Disclosure should be limited to what is necessary to portray the best interests of the children or to what is specifically being requested in the subpoena. If there is ever a doubt about what should be disclosed, it is best to seek advice from from a supervisor, the AAMFT board, or an attorney. Thank you for listening and have a great day.